please the court. Attorney William Vasili on behalf of the appellant Joseph Secriskey. Essentially, Your Honors, I'm waiving oral argument on my first assignment of error, and I only intend to orally argue the second assignment of error. And as this is a consolidated appeal, the trial court case number for that motion to suppress is the CR 2016-04-1163A, and the corresponding court of appeal case number is 28093. Essentially what we have here is on the early morning hours of April 12th of 2015, a individual by the name of Joseph Secriskey and his girlfriend are transported to the hospital for burns that were received due to an explosion of a chemical nature that caused burns to the skin. Mr. Secriskey's girlfriend, from what I can glean in the record, was not harmed, but Mr. Secriskey himself is the one who sustained those burns. The dispatch sent out Officer Braun to the site, which was 1294 Manchester Road. When Officer Braun arrived, it was approximately 7 a.m. according to what's in the transcript for the motion to suppress, as well as what's in the transcript for the trial. And essentially what he does is assess the scene. He walks around this home. He observes a 55-gallon trash can on the side that contains two 2-liter bottles that, according to him, have some sludge in them, as well as, I believe, a coat that appears to have some charring or burn marks on it. He then enters into the dwelling, knocks on the doors for the 2 first-floor apartments, and then has to exit the home in order to go around the back and go up the back staircase to the 3rd apartment, which is an upstairs apartment. At the trial court level, it was gleaned that, Officer Braun assessed the scene, could not see any fire, could not see any smoke, did not hear any people, nobody answered any of the doors, and by all accounts, it seems that the building and all 3 apartments inside that building were vacant at that particular moment. Officer Braun did testify that when he was originally dispatched at 7 a.m., he was not dispatched to that location, but he was supposed to be dispatched to the hospital. And I would submit that that's of particular importance, because what we're essentially dealing with here is a exigency to the warrant requirement. Now, Officer Braun himself did not enter the dwelling. It wasn't until his sergeant arrived that he went and fulfilled his official duties on that morning, which were to go to report to the hospital and check on Mr. Secriskey and investigate him, interrogate him, whatever his obligations were there.
What about the issue of the missing child?
The missing child, Your Honor, at that moment, and in that point in time, Officer Braun had no knowledge as to who was or was not supposed to be in that home. He wasn't even supposed to be there. He was actually dispatched to the hospital, and he, of his own volition, decided he wanted to go to Manchester Road. So from what I can gather from the record, he had no knowledge of anybody that was supposed to be there or not be there at that point in time. He just knew that somebody had, and it's not exactly clear as to whether or not EMS transported him, but I think that he transported himself to the hospital. And that's where, I believe someone at the hospital, my assumption is, notified law enforcement, and that's how Officer Braun became dispatched to this particular, and of his own volition went to the house. After his sergeant came, and the name eludes me as to the sergeant's last name, he spoke to his sergeant, said, "I'm going to go to the hospital, will you secure the scene?" That sergeant then secured the scene. A member of the Summit County Drug Task Force, Detective Wagner, who was an officer with the Springfield Police Department, was notified. He was not working that day according to the record, but he came, even though it was his off day, to report to the scene. He indicated in the suppression hearing, as well as during the trial, that he arrived on scene about 8 o'clock. So an hour in time has already lapsed. What we do know about the production of methamphetamine is, at least from the suppression transcript, that there, and the trial transcripts, there are 2 ways to do the one-pot method, or the shake and bake method. One would be the long form of cooking, which would be not adding water to increase the speed of the reaction. The other form would be adding water to that chemical, that compound of chemicals, which would increase the reaction. And according to his testimony at the trial, after you add the water, it's probably about a 2-hour process. So from his own experience, we know that the process through which this methamphetamine is cooked, based on the information that he saw outside, and ultimately after Officer Wagner went into the house, he observed an exploded 2-liter bottle. We know that there was this method of cooking meth. We have some evidence in transcript to tell us the time frame in which, or rather, some evidence to suggest how long it would take to cook meth using that particular process. And that's a particular note because what we have here is an exigency to the warrant requirement, and it's based on the emergency aid exigency. When Officer Wagner arrives on scene, he does not initially make entrance. So we have Officer Braun arrives at 7 a.m., Officer Wagner arrives at 8 a.m., and then does not make entrance, according to his testimony, until about 8:20 or 8:30. So we have about an hour and a half time gap. What we do know from his testimony at the suppression hearing and at trial is that while these chemicals are reacting in the 2-liter bottle, it's important to have first a plastic bottle being used so that the bottle can expand and contrast as the gases build up inside the tube. We also know that those gases build up relatively quickly and the bottle itself has to be gassed, which I'm sure I'm not telling the court something it does not already know. In that time frame, if there was actually an emergency between 7 a.m. and 8:30 a.m., most certainly that bottle would have erupted if it were still an active lab at that point in time.
What if there were more going on at the same time?
If there were, are you saying that if there, from 7 a.m. to 8:30, if there were more bottles going on inside that point in
You
time?
started them earlier or whatever, I mean, they may have been various stages of production, right?
Well, I'm not sure I understand your question, Your Honor.
There
If
could have
there,
been more than just one.
well, there were 2 in the trash can. He didn't know, but my point being, we know that the individual was transported to the hospital. We know that if there were more in that time frame, 7 a.m. to 8:30 a.m., they would have exploded. So even the officers on scene, the initial ones, did not treat it as an emergency. And I think that's why the time frame is so important, is that they rested back on this exception that wasn't really an exception because the circumstances did not deem it as such. My point being, of course, that if they really thought there was another reaction vessel going on inside the home, Officer Braun, who did testify at this suppression hearing, he has, in his experience as a law enforcement officer, interacted with active meth labs, had this information, he would have entered the dwelling. Even more so, Officer Wagner, who testified that he's been working with the Summit County Drug Unit for 10 years, and 2 years before that, he was working with meth labs. He himself did not initially just barge into the house.
Well, if it was ascertained that there were no residents in any of those 3 apartments, then really the only damage that could have happened would have been property damage then, right? Since nobody was answering the doors.
That would be what I would submit. That would be, now the officers did testify that nobody answered the doors, so I don't know that they actually ever admitted that there was nobody there, but nobody came out of the house afterwards, or the apartments afterwards. There was nobody that they found incapacitated doing it. And so they did testify, I guess, Officer Wagner and Officer Braun, when they got there, that the windows to the upstairs apartment were open, so there was ventilation inside the apartment. That's how they were able to smell the chemicals. And it wasn't until about, like I said, 8:20, 8:30, that it wasn't even Officer Wagner. They didn't kick the door in. They had another officer crawling through the window that was accessible, the bathroom. The way I'm sort of envisioning is you go up the back stairwell, the front door to the upstairs apartment is right there, and either to the right or left, it's not specified, there's a window where you can access the bathroom on the first floor. Another officer went into that bathroom window, observed the home, and then came in and unlocked the door. And what I would submit to you, Your Honors, is that after that initial officer went in, she didn't testify, but she would have been able to ascertain whether or not there was an immediate emergency there. Officer Wagner could have asked her, and they chose not to do that. Instead, what they chose to do is just enter the dwelling and not step back, secure the scene, and then go get a warrant. And that's what I think should have been done. There was no emergency, because if there was an emergency, they would have entered a lot more expeditiously, and they chose not to do that.
Are you saying that what the proper course of action would have been is after she entered into the residence and found out nothing was about to explode, she should have climbed back out the window and they should have gotten a warrant before they came back?
She could have gone out the front door and then secured the scene. So the most, we look at meth labs, at least in case law, and we fit them under this emergency aid exception.
I understand that, but they're already in, right?
Mhm.
So a warrantless search has already happened the second they go inside the apartment. So why are we not done now with that analysis of whether or not it was
Well-
reasonable to go inside?
Well, I think, Your Honors, what I would say is that the first part of my argument, of course, is that they shouldn't have been in the house in the first place.
I
Yeah,
understand.
that's my first argument, but if we go down and we go down the road of that, they had to take that initial step to go in there secure, which I would submit they did not. My position would be that they should have procedurally gone and got the warrant afterwards before they seized that property. So the most like scenario I can develop in my mind is that if they had gone in there and seen cocaine or something else, they could not have taken that cocaine. They would have to go get a warrant, I think, and seize that. Or they couldn't have searched around. They didn't have time to, and in this case, unlike cocaine, they can't say it's not readily identifiable as to what it is. Now, they claim because of the smell and because of the location, they thought it was. But again, I would say that they should have stepped back and wanted to get the warrant to do that. I think that's procedurally what is correct. I don't think that emergency aid exception gives them a carte blanche search inside the home.
Is that only germane because in this particular case, the person that entered the residence first did not testify? Is that the only? Because you're saying they got all this stuff that didn't get suppressed, that came in as evidence, but we never heard the person who actually did the search say what they saw.
I think that is germane if you get over the first hurdle. So if you get over the first hurdle, which is that it's not an emergency situation, if you look at the time frame that these officers used, obviously they didn't treat it as an emergency situation. Because if they had, known what they know, they would have realized that over an hour and a half time period, a one-pot method of cooking meth could have exploded if in fact it was active. If they really thought there was a second bottle in there, or if they really believed that the lab was still active, over the course of an hour and a half, they would have gone in. And the fact remains that they chose not to, and I would submit they chose not to, because they knew it wasn't actually the case. They knew there was not an emergency there.
Do they have to wear protective gear when they go into those places? Or they're not, I mean, can you just, can officers burst into a place like that with the fumes and the stuff going on, or do they have to get protective gear on to go in to begin with?
And it's not in the record, in my experience, they most certainly can enter if it's an emergency situation, whether or not they choose to do that. For cleaning processes, I believe, and this is again not in the record, and I don't mean to be improper, but for cleaning processes, I think that they used to bring a special team in to clean. I don't know what the local law enforcement do here in this situation now. So I guess
Can I have just one more question in
Sure.
regard to the motion to suppress? I know we have attached to the state's briefs, the court said the motion to suppress is denied. Was there anything else that was, any other actual findings of fact or anything, Brandon?
Not to my knowledge, Your Honor. I mean, unless they were transmitted in the record, the motion to suppress being denied was that way. So
That's all it was just a journal entry, so
Yeah.
it's denied.
that's my recollection, Your Honor. So I don't think that there was and I was obviously not trial counsel, so I don't know.
So we're not sure really why the trial court did what she did.
Correct. That's part of my confusion. So I guess in summation, Your Honor, I mean, the first part of the threshold is, like I said, I think, and I guess I should add one more fact, that it was particularly interesting to me is that we don't know when this actually started. We know that the state made a big deal about when the Sudafed was bought at 1 a.m. that morning, and then the explosion took place at 7 a.m. But overall, I think that there is an unclear timeline in this case. But I think for certain we do know that there's an hour and a half period, and it's an hour and a half. I'm sorry, Your Honor.
And you're out.
Oh, sorry.
Just sum up.
Yeah, essentially that due to that time frame, it is such that when you look at it, the officers didn't treat it as an emergency. Therefore, this court should conclude it was an emergency, and we'd ask this court to reverse and remand the decision of the trial court. Thank you.
We will take the matter under advisement and issue a written opinion, and that will be sent to you and to the state of Ohio, as well as we'll release it on our website. Thank you so much.
Thank you very much, Your Honor.